In this segment, we'll be discussing higher law in the American founding. I'll begin with a few words about early colonial America before focusing on the founding era. Early American settlers were almost uniformly Protestants who wanted to build, in John Winthrop's words, a city on a hill, which is referenced in Matthew 5:14. Especially in New England, they desired to create political institutions and to craft laws informed by biblical morality and by the higher law. This mission is illustrated well by the 1672 declaration by the Connecticut General Court, and I'm quoting here. "We have endeavored not only to ground our capital laws upon the Word of God, but also all other laws upon the justice and equity held forth in that Word, which is a most perfect rule." In Massachusetts Bay, the Puritans' commitment to crafting laws based upon the Bible sometimes led them to adopt what seemed to us to be harsh punishments. For instance, in England, adultery wasn't punishable by death, but the Puritans, following Levitical law, made it a capital crime. And yet, they often didn't enforce these harsh laws. Only 3 persons were killed for adultery throughout all of New England's history. On balance, the reforms had a liberalizing effect on criminal law. In 17th century England, a person could be put to death based on circumstantial evidence. But the Puritans, drawing from Deuteronomy 19:15, required 2 witnesses to the same act in capital cases. Similarly, a third of all English criminals were sentenced to death. A person could be executed for stealing property worth little more than a shilling. But American Puritans interpreted biblical texts such as Exodus 22:4 to require restitution as a penalty for theft rather than death. The Puritan commitment to the Bible and the higher law also led them to ban slavery except in the case of, quote, lawful captives taken in just wars, and such strangers as willingly sell themselves or are sold to us. When the Massachusetts captain James Smith kidnapped 2 West Africans and brought them to Boston in 1645, the General Court considered charging him with man-stealing, which is prohibited by Exodus 21:16. The court decided not to try Captain Smith because his offense took place outside of the court's jurisdiction, but it ordered the 2 men to be freed and returned them to Africa at the colony's expense. In 1700, the Puritan minister Samuel Sewall published the first anti-slavery tract in North America, The Selling of Joseph, a memorial. But we should leave the Puritans and fast forward to the American founding. In 1763, most colonists in British North America were proud to be a part of the British Empire. They were represented in their local legislatures, which in turn taxed them to provide for the general welfare. The English Parliament had the right to tax people in England, but not citizens elsewhere in the empire. In 1764, to help repay the debt incurred during the French and Indian War, Parliament enacted the Sugar Act, which attempted, for the first time, to raise tax revenue from the American colonists. A number of individuals and colonial bodies immediately objected that the act was unconstitutional. The following year, Parliament passed the Stamp Act, which again attempted to raise revenue from the American colonists. Again, many Americans denounced the measures on constitutional grounds. Patriots did not merely rely on constitutional arguments, as indicated by Samuel Adams's famous 1772 pamphlet, where he discussed the rights of colonists as, and I'm quoting here, as men, as Christians, and as subjects. By rights of subjects, he meant constitutional rights. And by the rights of men, he meant, in his own words, natural rights. That is, rights grounded in the higher law. He went on to explain that the colonists' rights as Christians may be best, and I'm quoting here, understood by reading and carefully studying the institutions of the great lawgiver and head of the Christian church, which are to be found closely written and taught in the New Testament. Parliament's unconstitutional actions were problematic, but its violations of the higher law were even more troubling. In my book, Proclaim Liberty Throughout All the Land, I discuss at some length biblical and moral arguments in favor of the War for American Independence. But let me focus on the most important text produced in the conflict, the Declaration of Independence. Approved on July 4, 1776, the Declaration justified America's break from Great Britain to the world. The entire document is worthy of careful study, but I want to focus on the stirring proclamation that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. These words have been accurately described as articulating the fundamental principles upon which America's experiment in self-government are based. Now, some people today brush off these words as window dressing. They're wrong. They were taken seriously and literally by Lemuel Haynes, an African-American preacher who quoted them in an anti-slavery pamphlet written just months after the Declaration was printed. Nor were they treated as void of content by Frederick Douglass in his famous 1852 speech, "What to the Slave is a 4th of July?" After describing the evils of slavery, Douglass observed that, and I'm quoting, "Notwithstanding the dark picture I have this day presented of the state of the nation, I do not despair of this country. There are forces in operation which must inevitably work to the downfall of slavery. The arm of the Lord is not shortened," Isaiah 59:1, "and the doom of slavery is certain. I therefore leave off where I began, with hope, while drawing encouragement from the Declaration of Independence, the great principles it contains, and the genius of the American institutions. My spirit is also cheered by the obvious tendencies of the age." Finally, Abraham Lincoln did not consider the promises of the Declaration to be meaningless. Sometime after his election in 1860, he penned a private set of reflections on the relationship between the Declaration and the Constitution. Lincoln observed that the Declaration articulated the principles upon which America was founded, and that the Constitution was intended to bring these principles into effect. He concluded his thoughts by using Proverbs 25:11, "A word fitly spoken is like apples of gold and pictures of silver," to compare the two. The assertion of that principle at that time was a word fitly spoken, which has proved an apple of gold to us, the principles of the Declaration. The Union and the Constitution are the picture of silver, subsequently framed around it. The picture was not made to conceal or destroy the apple, but to adorn and preserve it. The picture was made for the apple, not the apple for the picture. Lincoln's Emancipation Proclamation and his support of the 13th Amendment, which abolished slavery, did much to help the nation realize the promises of the Declaration. For present purposes, it's worth noting that the higher law principles articulated in the Declaration have been appealed to throughout American history by abolitionists, by women's rights activists, and leaders of the civil rights movement, and others. Looking to higher law principles to help inform law and public policy has a long and distinguished history in the United States. But because the focus of this segment is on the American founding, let me return to the era to illustrate how one leading founder understood and explained the implications of the higher law. America's founders regularly appealed to the natural law and to natural rights, but they seldom addressed these subjects in a systematic manner. The most prominent exception to this rule is found in James Wilson's 1790 to 1792 law lectures at the College of Philadelphia, now the University of Pennsylvania. Born in Scotland and educated at the University of St. Andrews, Wilson immigrated to America in 1765, and he quickly became one of the most prominent attorneys in the nation. The signer of the Declaration of Independence and an important nationalist at the Constitutional Convention, Wilson was one of Washington's first appointments to the United States Supreme Court. He served on the court until his death in 1798. In his law lectures, Wilson, drawing from the Anglican theologian Richard Hooker, observed that there are two types of law, divine and human. He went on to explain that there are four species of divine law: the eternal law, celestial law, natural physical laws, and natural moral laws. Like Hooker, he thought that human law must rest its authority ultimately upon the authority of that law which is divine. Practically, this led him and all but one Supreme Court justice prior to John Marshall to publicly assert that the Supreme Court could strike down an act of Congress if it violated the natural law. Wilson followed Hooker in many respects, but unlike him, he offered a rich account of the natural rights possessed by individuals. He argued that because natural rights are grounded in the higher law, they exist prior to government. Protecting these rights is any government's most important responsibility. He asked rhetorically, and I'm quoting here, "What was the primary and principal object in the institution of government? Was it, and I speak of the primary and principal object, Was it to acquire new rights by a human establishment? Or was it, by a human establishment, to acquire a new security for the possession or the recovery of those rights, to the enjoyment or acquisition of which we were previously entitled by the immediate gift or by the unerring law of our all-wise and all-beneficent Creator? The latter, I presume, was the case. So what exactly are the natural rights of individuals that must be protected by the government? There were and are many, but I'll focus on what is arguably the most important of all rights, the right to life. America's founders were committed to the core Christian idea that all humans are created in the imago Dei, the image of God. In a Supreme Court opinion in Chisholm v. Georgia, a 1793 case, Justice James Wilson paraphrased Psalm 139, observing that man, fearfully and wonderfully made, is a workmanship of his all-perfect Creator. He echoed this conviction in his law lectures. One practical implication of this is that innocent life must always be protected. Wilson wrote with evident approval, and I'm quoting here, "With consistency, beautiful and undeviating, human life, from its commencement to its close, is protected by the common law. In the contemplation of the law, life begins when the infant is first able to stir in the womb. By the law, life is protected not only from immediate destruction, but from every degree of actual violence, and in some cases, from every degree of danger." Wilson adopted the common law understanding of when human life begins, but if he had access to contemporary medical understanding of fetal development, there is little doubt that he would contend that life must be protected from conception to its natural end. Wilson moved on in his lectures to criticize ancient societies such as Sparta, Athens, China, and Rome for the practice of killing or exposing unwanted infants. Like most legal theorists, he condemned suicide because, and I'm quoting here, "it was not by his own voluntary act that the man made his appearance upon the theater of life. He cannot, therefore, plead the right of the nation by his own voluntary act to make his exit. He did not make, therefore he has no right to destroy himself. He alone, whose gift the state of existence is, has the right to say when and how it shall receive its termination." Contemporary Americans would do well to reflect on the importance that Wilson and other founders placed on the right to life. Abortion on demand ends far too many lives in far too many states, and physician-assisted suicide is now legal in about 10 states in the District of Columbia. Some Western European countries are far ahead of the United States, and it is not unheard of for physicians to help people end their lives because they are depressed or simply conclude that, quote, "life is not worth living." Treating such individuals with respect and dignity means getting them the help they need, not killing them. And only in the most extreme and rare cases involving medical necessity should the life of an unborn baby be ended. America's founders were influenced by their commitment to the higher law in numerous ways. It informed their understanding of natural rights, which motivated patriot support for the War for American Independence, a war necessary if they were to continue to enjoy these rights. As well, it led them to embrace a constitutional order committed to protecting rights, rights articulated well in the Declaration of Independence. They were unable to fully protect the rights of all Americans in the 18th century, and even today the rights of all Americans are not fully protected. Americans are blessed to live in a country whose founders believed in and were committed to a higher law. Like America's founders, we should all engage in political activity to ensure that the rights of all citizens, and indeed all individuals throughout the world, are fully protected.